Senate Judiciary Committee will come to order. And we have on the agenda today two proposed constitutional amendments regarding selection of Kansas Supreme Court justices. The two proposed amendments, before we get started with that, have one committee member change to announce for today, March 4th only, that Senator Francisco has been appointed to replace Senator Carson on the committee today only. So welcome to committee, Senator. And with that, then looking at how the testimony has come in, we will go ahead and open the hearings on SCR 1621 and SCR 1622, if it's permissible with the revisor to have the hearings at the same time, because there's a lot of overlap, I think, between the testimony and the issue. So I want to confirm first with the revisor that that would be appropriate. And the revisor has agreed that that would be appropriate procedure. So with that, then, I will ask for a bill brief on SCR 1621, proposing a constitutional amendment to provide that the governor will appoint Supreme Court justices subject to Senate confirmation and to eliminate the Supreme Court Nominating Commission. Mr. Revisor, Mr. Thompson, thank you.
Thank you, Madam Chair, and good morning, committee. So we'll begin with SCR 1621. And actually, we'll begin with a brief overview kind of the current system. The chairperson asked me to include that in the bill brief and in the oral presentation here. So you'll see that in both bill briefs, the second paragraph is the same. It just gives you a very brief overview of the current system, and that would be Section 5 of Article 3 of our Kansas Constitution. It provides that justices of the Supreme Court are appointed by the governor from a list of 3 individuals submitted by the Supreme Court Nominating Commission. The Nominating Commission is a statutory body, or a constitutional body. It's created in Section 5 of the Constitution as well, and its membership is defined there. It's 9 members, 5 attorneys, 4 non-attorneys. And then the other key points, I guess, of the current system are that when you have a new justice who is appointed by the governor, they have an initial term that ends 1 year after their appointment, following the first general election that occurs after that 1 year. So if an appointment were to happen now, for example, their term would end 1 year after the next general election, which is in 2022. So they would stand for retention in November of 2023. So, for example, with the Court of Appeals judge that you just had this same issue with, if you were to confirm Judge Coble, or Cobble, I can't remember the pronunciation. Thank you, Madam Chair. The retention election would happen in November of 23, for example, if the appointment were to happen this year. If a justice is retained, their regular term is 6 years. And at the end of that term, they are eligible to stand for retention. So that's the very basic summary of our current system that uses the appointment and nominating commission and retention process. So shifting then to the proposals, first SCR 1621, this proposal would amend the constitutional provision to provide for Senate confirmation of justices, and it would also eliminate the Supreme Court Nominating Commission. So under this new proposal, the appointment and confirmation process for justices would be similar to the appointment and confirmation process for the Court of Appeals judges that we just went through the other day, that's provided in statute at KSA 20-3020. So the governor would appoint a qualified person, or if the governor fails to act, the Chief Justice would appoint a qualified person, and then the appointment would require the consent of the Senate. There are time frames provided, action within 60 days, that sort of thing, just as it is for the Court of Appeals. The concurrent resolution, of course, requires a 2/3 vote by each chamber to be presented to the electors at the next election. And in fact, both of these resolutions have the special election date of August 2nd, 2022, which would be held in conjunction with the primary election that's held on that date. So both of these would be on the August 2nd ballot by their current provisions. And if you'd like, Madam Chair, I can stop there and we can talk about the first resolution, or I can briefly describe the second and take questions then, whichever way you'd like.
Thank you, Mr. Thompson. We will go ahead and stop there, committee, and ask the reviser any questions that you have regarding SCR 1621. So any questions for the reviser? Senator Gossage.
Thank you, Madam Chair. Mr. Reviser, just to clarify, so currently with the Court of Appeals, when I read through this and when you were explaining it, it is different than how we do Supreme Court justice nominees, correct?
Mr. Thompson.
Madam Chair, Senator, that's correct. So until 2013, both were the same, very similar anyway. And in 2013, the legislature enacted KSA 20-3020, which took the Court of Appeals to a Senate confirmation process. And since that time, they've been different.
So could you just then clarify the differences between the two? So Court of Appeals, the governor selects a nominee, and then that is brought before the Judiciary Committee for confirmation or for our determination of how, if we're going to pass that person out of committee. Then it goes to the floor, and then there's confirmation on the floor, or it fails on the floor. Is that accurate for the Court of Appeals?
Madam Chair, and Senator, yes. So the statute requires that the governor appoint a nominee that's qualified based on all the statutory and constitutional qualifications, and that is submitted to the Senate. And then by Senate procedure, you could have it go straight to the floor. So I don't want to say it has to come to the Judiciary Committee, but the practice has been that it is referred to a committee, this committee typically, in each case, and then you can make a recommendation on that nominee, or no recommendation, as you may recall. But ultimately, the key piece is that the Senate has to have a vote one way or the other. In fact, we had a case where a judge had been nominated, but they were not allowed to withdraw that nomination. A vote had to be taken to essentially decline that nominee so that the governor can make a new appointment. So you may recall that just a few years ago. So yes, that's the process. There's a nomination, Senate consent procedure, nomination and consent procedure, and then if the nominee is approved, they go to the bench, stand for retention, and if they're not approved by the Senate, then the governor gets to make a new appointment.
So then by clarification, by contrast, correct me if I'm wrong, so then with the Supreme Court justices, it's the same procedure. However, the governor can only select from 3 nominees that have been given to the governor by the Nominating Commission. Is that accurate?
Madam Chair and Senators, so the governor does select, and right now the selection is from one of the 3 nominees submitted. There is a provision, I believe, to get a change in nominees under very limited circumstances, so I'll just reference that, but not really important for this purpose. But generally speaking, they have to choose from those 3 nominees. But then there is no Senate confirmation under the current law, right? So the governor picks from one of those 3 candidates, that person is appointed and is sworn in then at the appropriate time.
Oh, so there is no confirmation from the Senate. Thank you for clarifying.
Right. So,
thank you, Madam Chair.
Thank you. Committee, other questions for the reviser on SCR 1621? Seeing none then, bill brief please on SCR 1622, and if you'll read the short title as well. Thank you.
Very good. Thank you, Madam Chair. Yeah, I kind of skipped that on the first one. I'm used to you saying it.
Oh, that's why I said it for the first one, but not the second one.
Yeah,
Thank you.
I'm used to not duplicating the 2, but that's the first line of the bill brief usually, so I'll go ahead and read that. So SCR 1622 is proposing a constitutional amendment to provide for partisan statewide election of justices of the Supreme Court and to abolish the Supreme Court Nominating Commission. So that's the other one we're talking about. And I apologize for not being perfectly clear before that the other one, takes us from the appointment and no confirmation to appointment and confirmation. So I think we've cleared that up, and that's good. And in this one, we'd be taking it from appointment and no confirmation to direct partisan statewide election, which is maybe a little bit easier to follow. So most of the provisions in the bill are stricken, right? So are in the current constitutional provision are stricken. We would abolish the Nominating Commission. It would not have retention elections. It would not have any of those procedures because following each 6-year term, a justice would stand for election or re-election. And that's how all the future justices would be elected. They would be partisan, they would be statewide, state election laws would apply to these races to the extent that they're not otherwise exempted under the Constitution or another statute. The current justices, I felt like it was important to highlight this, the current justices would all hold office for the term for which they were just retained or appointed. So if you have a justice who stood for retention and got a 6-year term, they would finish that 6-year term. And when that is over, that position would be up for election. And they could seek election to that position, or they could decline to seek election for that position. So rather than standing for retention, they would stand for election. And it would be an open race that other folks could also run for election in. The only other thing I would highlight, I suppose, is that justices would be eligible for election. So any qualified person would be eligible for election to the office. But a justice would not be allowed to seek re-election if, of course, they were required to retire, or if they had been, otherwise required to resign or had been removed from office. Then they would not be allowed to seek re-election or election to that position. So I think that pretty well covers that one. It's a little bit more straightforward, and I'd be happy to answer any questions you might have.
Thank you. Committee, any questions for the reviser? Senator Francisco.
Thank you, Madam Chair. So if this were to be adopted, then the prohibition of political activity would still remain for judges of the district court, but be eliminated for those judges of the Supreme Court.
Mr. Thompson?
Thank you, Madam Chair and Senator. Nice to see you here on this committee, and as usual, your keen eye caught a minor point that I did not mention, but I'll be happy to elaborate on. So you may recall, so first step, I suppose, is the elimination in Section 8 of Article 3. That's on page 3 of the bill, right in the middle. There's an amendment to Section 8 of the Constitution that would be required so that judges could have political activity, or justices, or folks seeking to be a justice could have political activity. Right now, that's prohibited by the Constitution because they're nonpartisan. This would, because it's a partisan statewide race, that provision would need to be struck in order to effectuate that. We currently also prohibit partisan activity by judges of the district court, but only those that hold office under the nonpartisan method of selection. You'll recall that we authorize by statute each judicial district can select whether they're going to have nonpartisan selection using a nominating commission, or if they're going to elect their judges of their district. And as you may know, some of our districts do elect, and they are partisan, and so this prohibition on that activity does not bar those folks from campaigning.
Thank you. Committee, other questions for the reviser? Seeing none, then, thank you, Mr. Thompson. We have registered 10 persons who want to provide oral testimony in addition to those who have submitted written-only testimony. And we have a bit over an hour left. I would ask the indulgence of the committee to run a little past noon if that would be, we'll see where we are at noon. However, I'm going to stick as best we can to our appointed time of noon and leave time for questions at the end of proponent testimony and then neutral and opponent. So with the 10 that we have divided by 60 divided by 10 is about 6 minutes each, but we want to leave time for questions. So I'm going to ask that we limit testimony to 3 minutes. I will give a 1 minute warning, and then at the end of all the proponent and opponent, each separate, we will have questions. We do have amongst the 10, 2 that we could not determine based on the materials submitted, whether they were proponents or opponents or neutral. So if they can, we will leave it at that. So if you want to identify when you are called on, whether you are proponent, opponent, or neutral, that would be helpful. If you can identify that now, I will ask, the two are Mr. Eric Bolinder and Miss Brittany Jones, and then we can kind of get you into the category of the proper testimony today. So we're going to talk about the two resolutions at the same time, and then you're a proponent within your testimony of one or the other or both. You're a proponent for some change, and then it likewise with the opponents. You're an opponent of one position or the other, or you're an opponent of any change whatsoever. So I think that was what we received testimony on. So with that, then we will start with proponent in-person testimony and hear from Professor Stephen Ware first. So please identify yourself and welcome to committee. And once you've identified yourself, then we'll start the 3 minutes. Thank you.
Senator Warren.
And we'll need to make sure your microphone is on. Thank you.
Sure, I'll start again. Senator Warren, members of the committee, my name is Stephen Ware. I'm a law professor at KU. I testify today not on behalf of KU, but on my own as a concerned citizen. My professional life is not just teaching law, but publishing my research on law. And judicial selection has been a major area of my research and publications since the 1990s, quite a long time. And what I have shown and determined is that Kansas Supreme Court selection is, from a national perspective, quite extreme. In fact, it is the most extreme in the nation in terms of privileging the bar in state Supreme Court selection. And the reason this is troubling is because the job of a Supreme Court justice is not just a matter of technical professional skill, it's also making law. Lawmaking is part of what Supreme Court justices do. They do it in common law cases, not governed by a statute, and they do it in interpreting statutes and constitutions. This is a very traditional observation of courts throughout the Anglo-American system. Of course, Supreme Court justices push the direction of the law in one direction or another, and it matters whether you have conservative justices or progressive justices. The common law of more conservative states with more conservative justices tends to move in a more conservative direction. Same with statutory and constitutional law. So lawmaking, big part of what state Supreme Court justices do. We need to ask ourselves, shouldn't the system for selecting those justices be democratic rather than privileging one small subset of the population? I personally favor the indirect democracy of a Senate confirmation system. And when I hear defenders of Kansas bar privilege respond, they rarely talk about Supreme Court justices making law. Instead, they go into topics like the professional merit of judges selected under the current system. But I haven't seen any data suggesting that Senate confirmation states have justices with less professional merit than states with Kansas's system or similar system. Same thing with judicial independence and the rule of law, important values that are every bit as protected in states that have more democratic Senate confirmation systems than the Kansas current system. I hope, Senator Warren, I made it right at 3 minutes, and I stand for questions if there are any.
Thank you. Thank you. You did. Appreciate that. And next we will hear from Joshua Nye, partner at Kriegshauser Nye Law Group. And after that, we will hear from Alan Cobb, who is on WebEx. And with that, then please introduce yourself and welcome to committee.
Thank you, Chairman Warren and members of the committee. I appear today as an individual citizen as well. I'm not appearing on behalf of any group or even our law firm. I'm an attorney, a licensed attorney who has practiced in the state of Kansas actively for over a decade now. I have been interested in this particular subject of judicial selection since law school. And even before then, I remember attending judicial selection hearings even before and during law school in 2007, 8, and 9 in both the House and Senate. And I actually wrote my law journal article that was published in the Washburn Law Journal on Kansas judicial selection with respect to its relationship to the Equal Protection Clause and the one person, one vote doctrine. I've laid out in my testimony today my concerns today, not only as an individual citizen, but also as an attorney. I see a lot of people in suits behind me, many of whom I consider my colleagues and friends, at least one intern behind me, and I certainly don't relish the idea of being perceived as a sort of class traitor today as an attorney, but I appear here today because I don't believe in class selection of governmental officials. I think that the democratic process and democratic legitimacy has to undergird the selection of all of our three branches of government. And so I've laid out in my testimony specific numbers with respect to the minority, significant minority, that the attorney members or the attorneys that participate in attorney elections in Kansas represent with compared to registered voters or even the entire Kansas population. We as attorneys not only represent less than 0.2% in many elections when it comes to total voters in nominating commission elections, but we get to vote actually 3 different times with respect to that, those elections. The first being voting in the statewide election for attorney chair, second being electing a congressional district attorney person on the committee, and then finally voting for governor affects the appointment of those 4 minority, the layperson minority members of the commission. If I had more time, I would discuss today my personal observations in comparing and sitting through Senate confirmation hearings of Judge Stegall, Justice Stegall now, Judge Gardner, Judge Warner, and others in this very room since 2013. I've also had the privilege of sitting through the actual nominating commission interviews of applicants and have the ability to compare those two. If the committee is interested in further dialogue along those lines, I certainly can share that, but I want to be respectful of time today. I encourage you to read my written testimony and ultimately urge some sort of reform to the current system. Thank you.
Thank you. With that then, Alan Cobb, President and CEO, Kansas Chamber.
Thank you, Madam Chair and members of the committee, and thanks for allowing me to do this virtually. I'm in a little bit of a time crunch. I'm Alan Cobb, President and CEO of the Kansas Chamber, licensed Kansas attorney, admitted to the bar in September 1992. I'm here to support SCR 1621. I've testified on this topic many times in the past, so I'll probably be anticipating some of the opposition, and if that's opposition has changed in some of the talking points, then so be it. But as Professor Ware did a great job of explaining why Kansas is unique, but not necessarily in a good way, with the only state with the bar controlling the process. Even as an attorney, I do not find that a good thing. And I've talked to plenty of lawyers who think all 9 of the selection committee ought to be lawyers, that they are equipped with the knowledge and skills to select judges or justices. And there's really no other part of state government that's even close to being similar. Doctors don't support or select the Board of Healing Arts. Accountants don't select the Board of Accountancy, and university professors don't select the Board of Regents, and only one of those, the Board of Regents, even requires Senate confirmation. But yet, here are some of the other boards that require Senate confirmation: the Agricultural Remediation Board, the Corporation Commission, the State Banking Board, Human Rights Commission, the MOCAN Metropolitan Development District, an agency compact, Central Interstate Low-Level Radioactive Waste Commission, among others. And the fact that you don't have any say on the Supreme Court, though it does on the appellate court, I think is notable. Also, one of the arguments is we want to keep politics out of the process. Having been solicited for my support for members of the commission or the chairman, it's the politics of the merit committee may be a little less subtle than governor or legislature, but it's certainly there on the letters and the folks that are supporting one candidate or another. One thing that's likely to come up is the application of the triple play, which happened in the 50s, which led to the merit. There's no way that comes back with merit selection. With Senate confirmation. At that point, the governor could unilaterally select a Supreme Court justice. So that argument comes up. I'm very curious why they bring that up, because we're not going back to that no matter what. So I also wanted to clarify, the chamber does not have a position on the other resolution. We just have not discussed that among our membership yet, but we will be developing a position there. So thank you for the opportunity to testify, and would like to echo everything that Mr. Nye and Professor Ware said too. Thank you.
Thank you. I don't have any other proponent in-person conferees on the agenda other than possibly the two that we, the testimony was coming in, were not able to determine because no position was stated. So I will ask now, do we have proponent testimony from either Eric Bolinder or Brittany Jones? If we do, please go ahead and introduce yourself. And it sounds like Mr. Bolinder on WebEx has indicated he is proponent also. So
correct.
Please introduce yourself and welcome to committee.
Yes, thank you for having me, and I apologize for the confusion. I forgot to put that in the subject line. It was a long day yesterday. So anyway, thank you so much for having me today. My name is Brittany Jones, and I am I'm an attorney and the director of policy and engagement for Kansas Family Voice, formerly Policy Alliance of Kansas. Kansas Family Voice advocates for policies that strengthen families, stand for life, and protect religious freedom. And I'm here to voice our support for both SCR 1621 and SCR 1622. We believe that our judicial selection process for our Supreme Court is broken and it needs a serious fix. And we believe that either one of these resolutions could provide needed transparency and needed accountability. One of the most basic principles of maintaining the rule of law is that laws of society should be knowable and they should be fixed. The people in a democratic republic should be able to have some say-so and have some accountability for their elected officials. And that includes, and should include, whether or not they're elected or not, their justices. Those who govern and those who rule in the third branch of government should also be accountable. Accountability is not just for your executive branch. It's not just for your legislators. It should be for your judiciary as well. Now, we want to maintain their ability to make rulings based on the Constitution. We want to maintain that integrity, but they also should be accountable to the people. And we believe that either one of these systems does provide a level of accountability and a level of oversight. Now, of course, neither one of these systems is a perfect fix for every problem, but it does present a more fair and balanced way to approach these issues. The system that we currently use in Kansas is a very modern system, and does not have it's not rooted in the history of our country. It's not rooted in the way that we've ever selected justices, and we believe that this has led to gross injustice for the people of Kansas. And so we would strongly urge that you look at this system and make the needed reforms and allow the people of Kansas to not only have transparency and have some oversight over this system, but also allow them to vote and put this on their ballot. So I stand open for questions at the appropriate time. Thank you.
Thank you. Next, we will hear from Eric Bolinder, Managing Policy Council, Americans for Prosperity. Please introduce yourself and welcome to committee.
Thank you very much, Madam Chair Warren and the rest of the committee, for inviting me to testify on this important topic. I'll start by saying something that might sound surprising. In one way or another, Supreme Court justices are already elected. They're just chosen by a body that is majority controlled by lawyers, who themselves are elected by peers in the state bar. This one profession thus can control the critical process, and that totally insulates the Kansas Supreme Court from any political accountability by its citizens. This is important because the decisions of the Kansas Supreme Court affect all citizens, not just lawyers. This makes Kansas and any state that shares this judicial selection method distinct from the vision of the founders of our country. While the judiciary is supposed to check politics in the door, the selection process of the judiciary must, in some form or another, be accountable to the people. And that's what the founders of our nation wisely thought with the federal system. Other states take a different approach using elections, which is also a good approach. Either way, it's important that judicial selection be accountable to the people, all people, and not just members of one state. I think it's helpful to take a moment and talk through what makes a good judge. We consider typically things like judicial temperament, experience, demonstrated fairness, and character, and these are all critical. But as you've likely seen in recent headlines, judicial philosophy is a key characteristic of any judge. There's a couple different primary judicial philosophies. The first is originalism and textualism. That means judges applying the plain text of the law as understood at the time it was written to the facts of any given case before them. That means they must check their biases and political beliefs and fair results and respects the role of both the Constitution, state and federal, and the law as you, the legislator, have passed. There's a different type of approach too, and that's judicial activism. That's when judges bring their own views and policy preferences into the courtroom and let that influence their decisions. But judges, no matter how they are selected, are not put on the bench to make policy. That's what the folks in this room were elected for. The legislative process is the legislative process for a reason, and it has no place in a courtroom. And if judges are allowed to continue down this path, it can turn the judiciary into a super legislator, a body unaccountable to the people that can wield enormous power. So what does all of this have to do with how Kansas selects its judges?
1 minute.
The Nominating Commission is selected by a majority of lawyers that are elected by the state bar. And this is not some sort of nefarious plot. Lawyers who control the selection are going to pick people that are like them, and the legal profession tends to be left-leaning. Professor Brian Fitzpatrick from Vanderbilt Law School has written several books on the importance of judicial selection methods. The Missouri Plan, which Kansas uses, results in the judiciary that skew far to the left of the state's population. You have to remember, judges are government, an important part of government, and one very important government. That's why we need to have judicial selection methods that are accountable to the people. There are two selection methods that otherwise reduce drastic leftward skew. One is the federal model, which is one of the bills here. And it basically, the governor appoints, the Senate provides advice and consent, and this likely gets you furthest to the center. But not far behind is the other model, partisan elections. This too reduces leftward skew and results in a judiciary more representative of the center of Kansas citizens. These sorts of electoral races promote citizen involvement and help voters make informed decisions.
That's 3 minutes.
Yes, thank you, Madam Chair, and I'm happy to take any questions.
Thank you. Are there any other proponent conferees in the committee meeting room or on WebEx? Seeing none, then I will direct the committee and those following along that we do have proponent written only testimony from Mike O'Neill on behalf of Kansas Policy Institute, as well as Derek Schmidt, Kansas Attorney General, Office of the Attorney General. With that then, committee, we will open it up for questions, and we'll try to conclude at 11:30 our questions, but this is an important topic, so we'll see where we are at that time. But Senator Gossage, looks like you have a question. Senator.
Thank you, Madam Chair. This question, I guess, would be for Josh Nye. So under SCR 1621, when it says that the governor will appoint Supreme Court justices subject to Senate confirmation. So going back to the appoint Supreme Court justices. So if I understand this correctly, then the nominating committee or the attorneys in that commission, if there was a commission, or attorneys in general, could still recommend, right, that it's just the governor would not be limited to these particular three judges. So it would do away with the commission in general, but the attorneys, the Bar Association, whomever could still recommend attorneys to the governor, correct?
That's correct, and Senator Goff, that is actually a robust practice at the federal level, where you'll see high, in previous administrations and previous Senate confirmation situations, high involvement by the American Bar Association. They have what's very well known as a qualified or not qualified type of designation that they put on potential nominees or nominees made by a president that's subject to Senate confirmation. And so the American Bar Association, other groups, other alternative bar associations across the country, and not limited to attorneys, can provide input not only at the Senate confirmation process, but to their elected president at the time and to members of the president's staff that are working on these nominations. That happens all the time. And that's frankly what I think the legislature is very familiar with, which is robust, transparent advocacy to try to establish the legitimacy and qualifications of this particular nomination. And I would say that that also exists in statute currently with a lot of boards and commissions that were listed by Alan Cobb in his testimony, wherein trade groups, whether that be the Sheep Council or other agricultural councils or manufacturing councils, trade groups that are recognized in statute as providing input into the nominations, the whole difference turns on whether there's actual control by that trade group over the selection process, or if it's an advisory type relationship. And so the role of the bar would not change with respect to the ability to provide input in the process. It would simply remove the bar as the sole arbiter of who gets to go into the nominations. And I would say, I don't get the opportunity to correct Mr. Thompson very, very often, but I would take issue with one thing I think he said, and correct me if I'm wrong, is that there is not in the Constitution the process to redo nominations. Once nominations from the Nominating Commission are submitted to the governor shall appoint from one of those three persons. And if the governor does not do that within 60 days, the Chief Justice actually shall appoint from one of those three names. So if you take that in the context of some of the Senate confirmations that have actually been unsuccessful here, some of those same judges that were appointed by the governor and subject to Senate confirmation here, and they ultimately failed because of 11th hour revelations or something, or rather, those same justices, if they had gone through the current process, would be on the Supreme Court today, because there's no backstop to that governor's appointment. And the last thing I would say is that the Nominating Commission pool, what they can consider and ultimately give to the governor as far as the three names, in practice, that pool has been limited to only those who apply. And so once they apply, they hold 20 to 30-minute interviews with these candidates over the course of 1 or 2 days. It could be 10 candidates, it could be 16 candidates, it could be less than 10 candidates. They pick from those three, and then the governor ultimately has to pick from one of those three.
So the way I read 1621 is that this sounds exactly like we do it on the federal level. Am I right with that?
To my understanding, it is. I will say within the, and I've actually compared this language with respect to the current Court of Appeals federal model that we've used since 2013. But there is within that provision still holdover timelines under which the governor must appoint within 60 days. And so I think the committee would do well, and forgive me for not knowing whether that's in the current bill as far as the holdover or the Chief Justice's role in backstopping the governor if the governor doesn't appoint within a certain time. Or the Senate doesn't confirm within a certain time. But it's my understanding that, yes, in the current bill, that would be a federal model that we use currently with Court of Appeals as well as at the federal level.
And my final question, Madam Chair, is of the other states, how many of them do what we currently do as far as selection for the Supreme Court justices?
I would actually defer to Professor Ware on those particular that particular data. I do know, so I don't want to say something incorrect. I do know that Kansas is the most extreme in the sense that we have 5 attorney-elected attorney members on our nominating commission, and that represents a majority control at all times by bar-elected bar members who are picking the nomination, picking the pickers, so to speak.
Thank you. And Madam Chair, would it be okay if Professor Ware came to the microphone?
Sure, and I have a follow-up question for Mr. Nye if you want to stay close to the podium. Thank you. Go ahead, Professor Ware.
Thank you. Senator Gossage, Josh Nye accurately stated that Kansas is alone of the 50 states in being the only one where the bar selects a majority of the nominating commission. There are 8 states that are close to Kansas in how much they privilege the bar, and the remaining 41 states, nearly all of them don't at all privilege a lawyer over her fellow citizen in the selection of these lawmakers.
Thank you, and thank you, Madam Chair.
Thank you. Professor Ware, a follow-up question. I am reading through the written testimony from Derek Schmidt, Kansas Attorney General, and I see in the written testimony he has indicated that in 2005, as a member of the Senate, he began the debate on reforming the judicial selection process, and there was a Senate concurrent resolution then, and we have a couple of us before us now. And his testimony states that now, as in 2005, I am advocating this amendment out of a sincere belief that this reform will result in a stronger and better respected judiciary. Do you agree with that statement, Professor?
Yes, Senator Warren, I do. I think Derek Schmidt accurately points out that it's nearly 20 years now that this issue has come up again and again before this body. And that's because Kansas is out of whack with the mainstream of the country. We're off on the extreme, and Kansas voters really deserve a chance to weigh in on whether they want to stay there or not.
Thank you. And a follow-up question then for Mr. Nye and Professor Ware, if you'll stay close to the podium as well. Professor Nye, I'm sorry, Mr. Nye. So you had talked about in your testimony about the nominating commission, and I think you had said you had some further insight about how the nominating process is in place right now. Do you have any experience or insight into some of the questions that are asked of the nominating commission? Because it's my understanding that process of nominating commission interviewing the potential nominees isn't a public hearing. So do you have any insight about what those questions are, or what that process is like that you could expand upon and provide for the committee and others? Thank you.
Yes, and before I do that, I do have to...
and go ahead and identify yourself, please.
Sure. My name is Josh Nye, again, appearing as an individual attorney. Before I do that, I have to correct myself and say that Jason, I think, or Mr. Thompson was technically correct in terms of the nominating commission may choose not to send 3 names to the governor and kind of restart their process over. But once the names are sent, the pool is locked. So there is a process under KSA 20-134 that where the nominating commission can continue their deliberations until they send those 3 names. So apologies to Mr. Thompson. It looks like I'm buying lunch at some point. That said, I wanted to answer your question with regard to the specifically the nominating commission interview process, and give you some context regarding my observations of that, but also comparing that to the Senate confirmation process. The nominating interview process, I've had the privilege of actually attending 2 of the 3 last Supreme Court appointments. When those deliberations were traditionally closed as far as the actual deliberations, and the interviews at the Nominating Commission's discretion were opened to the public prior to 2016. In 2016, the legislature passed a law that actually made that process an open meeting or subject to the Open Meetings Act. And so the commission can only recess into executive session for very specific statutory reasons included in that bill. And so we've, since 2016, had far more ability to at least see what's going on in the questioning, not necessarily deliberations, although the actual deliberations and vote are public. There still is an extensive amount of time that's gone into executive session to discuss various things that the public cannot see. But that said, my experience in actually seeing the types of questions that are asked, this is not a robust Senate confirmation hearing. This is not what you would associate, for example, for those of you who were here or saw then Caleb Stegall and then Judge Stegall's confirmation hearing in 2013, where there was robust media debate and robust, the cameras that are pointed at me right now were pointed at him, and his writings were scrutinized in the public, in the legislature. There were advocacy groups that were involved in free speech and that type of deal. And then since then, there have been the same types of transparent democratic process surrounding Senate confirmations, surrounding then Judge Jack's appointment and failed Senate confirmation at the time, and then the follow-up appointment of Judge Sarah Warner at the time. And so comparing that to the actual questions that are asked in the 20-minute or 30-minute interviews in the Nominating Commission, this rarely is in my experience with these interviews, is the idea of judicial philosophy or approach to statutory constitutional interpretation asked of candidates. The types of questions I've written down that I actually transcribed when I was in the meeting are: outside of Topeka, any insight in bridging divides between the branches? Have you ever faced a challenging ethical dilemma? What lesson do you hope your kids have learned from you? What are your research and writing skills? Will you rotate law clerks, or will they be permanent? Why would being young be beneficial to the Kansas Supreme Court? I see that you've had ballet experience. Will there be a Supreme Court of Kansas ballet show at some point? And the Supreme Court requires collaboration in decision-making. Can you collaborate? Rarely is the type of rigorous confirmation questioning that you see on both sides of the aisle in confirmation hearings, like at the federal level and here at the Court of Appeals level, even addressed. And there is not enough time to even get to that in the questions. That said, obviously the Nominating Commission can change that practice. But I will say that there was a very notable exchange that I think shows why lawyers are actually not just neutral arbiters of who should be judges, but they actually have a lot of disadvantages in being involved in this process. And this is an example from the eventual nomination and appointment of Justice Wall from January 16th, 2020, when the commission was debating or beginning their deliberations on all the applicants to decide what characteristics they were looking for in the three names they were going to send to the governor. And ultimately, Lawyer 1 on the commission said, because our meetings are public now, some of us have trouble saying one candidate is better than another. Lawyer 2 then says, it's awkward to discuss personal characteristics with people staring at you. And then a layperson member speaks up and says, this is our public duty. We shouldn't feel embarrassed. And then a third lawyer member says, we have to look at these judges. I don't want to say something critical because I have to appear in front of them. And then the layperson pipes up again and says, fearful of retaliation. This type of awkward deliberation in the nominating process does injustice to the ultimate process of selecting our policy, or not our policy, our judges who have the effect on making law as Professor Ware said.
Thank you. I have a couple of other questions, and I think probably committee does too, but thank you. We'll go to Senator Francisco. And do we have then?
Thank you, Madam Chair. And I did have in my notes to go back to our revisor, Jason Thompson. So I'm glad that was cleared up because I was here during that process and I believe he did describe it appropriately. So I had a question that was just, does the vote on retention provide some accountability? I think I've heard several of the proponents say there's no accountability with regard to Supreme Court justices, and I see that as different as other trade groups. Those individuals never stand again for election. So perhaps Mr. Nye?
Mr. Nye, please go ahead and identify yourself.
My name is Josh Nye. I'm an attorney appearing in my individual capacity. It is true that what has not been addressed today so far at length is that there are retention elections in Kansas. After a Supreme Court justice is appointed by the governor after being one of the final 3 nominees sent by the Nominating Commission, that justice has to stand for their first retention election in the general election after their first full year on the bench. And so after that, it's 6 years after that. And so this year we'll have at least 2, maybe 3. I don't know how many retention elections that will be here at the general election this year. And that general election retention question is, shall this judge or justice be retained in office? It's a yes or no question. And I would argue that that process has been historically ineffective in providing accountability because my understanding, no Supreme Court justice in Kansas has ever not been retained. It's my understanding that only 1 or 2 district court judges that are subject to this process have ever not been retained in office, and that is at the level of impeachable type offenses there. So yes, there is, as you described, accountability to the voters. I would say that that is an anemic process that does not provide true, robust accountability or democratic legitimacy.
Thank you, Senator Francisco.
Thank you, Madam Chair. And I agree, the votes on retention are difficult. Probably votes on judges are the ones that most people come to me about because they feel that they don't have a lot of information with regard to that. The only other hope I would have is that the committee might take some time to look at other systems for selecting a nominating committee rather than just these 2 proposals that are before us. Thank you.
Thank you. Senator Haley and then Senator Thompson.
Thank you, Madam Chair, and thank the conferees that are bringing this before us. And Madam Chair, I am going to request when we go to the opponents that we do briefly revisit what brought us to this system, that being in part the triple play, that for those who may not be familiar with it, that we have a part of that discussion during the course of the next, because it has been suggested in this testimony, I think as Mr. Cobb's, that the system is now fixed to the extent that we can't relive what brought us to this current system, and perhaps a brief review might be in order. To Senator Francisco's query, I'd like to add that the Nominating Commission, and I don't know who wants to respond, certainly there are some concerns as to how those appointments are made, but the resolution, this instant resolution, says there should not be any other nominating commission. And would it not be preferred to still have this vetting process in place if we make some changes to the makeup of it? Wouldn't that be a median assistance so that we do have a vetting process through the Nominating Commission before these recommendations are made by those stakeholders and the practitioners who truly know the mechanics of the bar and of our system before passing these on, these recommendations on to the executive branch.
Is that a particular question or just a comment?
Well, it's a question. I mean, we're speaking to abolishing the prospect of nominating commissions, and there seems to be suggested by the conferees that the commission in and of itself is wholly an inappropriate procedure by which to do it. And so my question is to anyone who might be, wouldn't it work better to see a better commission named? Wouldn't that be, I think, a median alternative so that we still keep in place what has been, and I guess the second part of that, something that's worked very well. I think Kansans personally have been pretty well served by the selections that have been made through the process that we have. But rather than throw that out completely through a nominating commission, making up a different hybrid of those that are selected to the nominating commission, wouldn't that be preferred to entirely abolishing it?
Professor Ware, looks like you would prefer to answer. Go ahead.
Thank you, Senator Warren. Senator Haley mentioned the triple play. That was where a vacancy on the state Supreme Court was filled by a governor with no check on the governor, no constraint on the governor's power, in contrast to both the nominating commission system, which constrains the governor to 3 possible nominees, or a Senate confirmation system that constrains the governor by a check on the confirmation vote. So I don't think the triple play is relevant here in the sense that none of the proposals or existing system would leave the governor unchecked by anyone. It's just a question of which check, nominating commission or Senate. And then Senator Haley, as you point out, you can have both checks. You can have a nominating commission and a Senate confirmation. Many states have that system. And in those states, the bar does not play a role in selecting members of the commission. So those states have a democratically legitimate system that has vetting at both the commission stage and then the Senate confirmation stage.
Thank you. And thank you, Madam Chair. Mr. Nye.
Thank you. Mr. Nye, go ahead.
Very briefly, I would say that I don't think anything would prevent a governor from doing something like Governor Kelly has done in creating some sort of advisory group that would assist her in making an ultimate appointment, like has happened with her appointments to the Court of Appeals. And so I think that there are all types of governor's task force or other groups that the governor can either set up informally in order to solicit feedback. But I think this would prohibit at law potentially the nominating commissions being set up as a matter of law versus as an assistance, discretionary assistance to the appointing figure.
Well, thank you. And thank you, Madam Chair. To your last point, I'd be a little concerned to see a governor name the entirety of the commission. That too may have the taint, if you will, of, a direct influence over those members that would be named to that ad hoc advisory committee, as opposed to the system we have now where they're drawn by various divisions and distinctions. But
anyway, and I think that system currently exists, so that concern would be relevant to Governor Kelly's ad hoc committee as well.
Thank you. We're going to move on to Senator Thompson and considering the time considerations we have today. Go ahead, Senator Thompson.
Couple quick questions. This might be for the reviser, and perhaps I missed it, and I apologize if I did. With the current sitting justices, if leaping ahead, we selected, say, SCR 1621, would they then, if they wanted to be retained, have to go through the Senate process or confirmation process?
Mr. Thompson.
Madam Chair, Senator Jason Thompson, Revisor's Office. No, the current justices would just be standing for retention as they do right now. The confirmation process would only apply to a vacancy or a new appointment. And then, yeah. So.
And with regard to, we've heard a lot about 1621. We haven't really heard much about 1622. And I would welcome any comments because it looks like that would go toward the other end of the spectrum, where like Texas and Pennsylvania, if Professor Ware has any specific comments on that, I would appreciate that. Thank you.
Professor Ware.
Thank you. Senator Thompson, I think you characterized accurately moving from one extreme to the other extreme, with the sort of happy medium in the middle being a Senate confirmation system like we have for the Court of Appeals and like many other states have for their highest courts, and as we've had in the U.S. Constitution for over 200 years for our federal courts. All of those judiciaries have rule of law, judicial independence, every bit as strong as Kansas. There's no reason why those important values would be sacrificed by moving to a Senate confirmation system. In contrast, as we all know, contestable judicial elections are a very different beast entirely that raise a whole bunch of issues not raised by a Senate confirmation system.
You would consider yourself certainly neutral, if not an opponent of the SCR 1622.
Agree. I would not want to go from one extreme to another. I want the happy medium in the middle.
Thank you. Thank you, Professor Ware. Thank you, Madam Chair.
Thank you. And committee and those following along the line, I have, in the interest of making a correction, there is one other proponent conferee with written only testimony also in your folder, is from Senator Ty Masterson, 16th District, Office of the Senate President, Kansas State Legislature. And I have two questions for all of our conferees, any of our conferees, including those that are still on WebEx. And the first one is this. The Attorney General has stated in his written testimony that, as I read before, now as in 2005, advocating for the amendment out of sincere belief that this reform will result in a stronger and better respected judiciary. And then he proceeds to provide two reasons. The first is it is time for the people to vote. The fact that this debate endures after 15 years of consideration by the legislature in various forms clearly demonstrates that this is a real and legitimate issue about the nature of our Kansas system of self-government. The second reason given is, second, the federal system of judicial selection works and has for more than 2 centuries. For any of our conferees, do you agree with those two reasons proposed? First, the time for the people to vote and putting one of these proposed constitutional amendments on the ballot of Kansans would provide them that opportunity to vote. And second, would you clarify whether you are, the second reason given was the federal system of judicial selection works and has for more than 2 centuries. Do you agree more or less with that? And just short answers would be appreciated, and we'll keep them short. So for any of our conferees who haven't already addressed that, I believe Mr. Nye and Professor Ware have, but for any of our other conferees who have an answer to that? Yes, Ms. Jones.
Thank you. I can give a brief answer. So we would agree with those statements by the Attorney General. I talk to Kansans pretty regularly, and every time I discuss our Supreme Court, they are aghast at what the court is doing and that they are left unchecked. And so I believe the people of Kansas want this opportunity to have a say in the judicial system, and I believe that they're equipped and they're prepared to do so. And so I do agree with the Attorney General that it is far past time that we make some reforms to our system. I also would agree that the federal system, or the federal model, has worked very well. Now, of course, there are always disagreements on how some of those things go, but it provides an opportunity for our democratic republic to go through this process, and it is done in a way that allows input from many different people and allows checks and balances. Our current system in Kansas does not do that, and so we firmly believe that this should be reformed. Thank you.
Thank you. Do either of the conferees who are on WebEx have a short reply? I think we have one that Mr. Nicholson is indicating, and it is Mr. excuse me, let me make sure I get it right. Mr. Bolinder, go ahead.
Yes, Madam Chair. Thank you. Eric Bolinder with Americans for Prosperity. I do agree with the statements you read, and I'll say if you look at my testimony, you'll see that there's a lot of data to back up that either of these systems that are proposed in both your bills today will reduce what is otherwise a hard leftward skew in the judiciary and move it more to the center and more representative of the citizens of Kansas. So yes, I agree with those statements.
Thank you. With that, then, I will turn to my second and last of the questions that I have. We have written testimony from Senator Ty Masterson, Senate President, and he talks about in his written testimony a couple of prior, well, one is he has said that the Kansas Supreme Court inserted an unfettered right to abortion into our 1859 state constitution. And his testimony goes on to say that this ruling was made possible by a flawed system which is rigged to allow justices with radical judicial philosophies to be appointed to the Supreme Court without the check of Senate confirmation. My question is, do any of our conferees who have testified have an opinion regarding that statement, whether they agree with it, whether they don't agree with it, or something in between, a comment on that? Because I think as I talk to Kansans, that's something that I hear about. So I want to know from the conferees what their position is. Thank you. Ms. Jones?
There's someone else on WebEx. I don't want to hog all the questions. Yes, we would agree with that statement from Senator Masterson. And I
want to identify who you're with.
Oh, I'm sorry. I'm Brittany Jones, and I'm with Kansas Family Voice. I'm a director of policy and engagement. Yes, we would agree with that statement. I personally agree with that statement. I believe when you look at the Hodes and Nauser versus Schmidt decision, it is quite a shocking opinion how it is unmoored from our Western legal philosophy and Western legal thought. They have relied upon some very liberal papers that don't truly represent the history and the understanding and the culture of Kansas. And I believe that's shocking to most Kansans, and it's shocking. It was shocking to myself as an attorney that they were so unmoored themselves from our judicial and our Western legal thought. So yes, I would completely agree with that statement from Senator Masterson, and I also referenced it in my testimony. I believe that this is something that really shows how flawed the system is and the impact it's having on the state. Thank you.
Thank you. Do any of the other conferees have a position or reply? Yes, Mr. Nye.
I believe it's, my name is Josh Nye. I'm an individual attorney appearing in individual capacity. I believe it's for this body and the people of Kansas to decide if there's a causal connection between the types of decisions we've seen out of the Kansas Supreme Court and the method of selection. I think that we had recently a 6-1 decision reading a right to an abortion into our 1859 Constitution. That decision legally, from a legal perspective, was more expansive and more protective of abortion than Roe v. Wade. And that's as a result of having a strict scrutiny standard without a tiered system. And so that type of decision we see in federal courts on both sides all of the time. But there's also, I believe, the potential for a causal connection, but that exact same decision received a 7-7 split when being considered by a court of appeals sitting en banc, 14 judges. It was a 7-7 split with 3 different types of judicial rules that were being applied to this idea of a newfound rule to be discovered in the Constitution, emanating from the penumbra of of the text. I think this body should be asking itself as well whether there's a reason and a causal connection that certain activist groups on one side of the political aisle routinely seek to expand new theories and find new expansive rights through litigation that would be found in the penumbra of the Constitution rather than its text, and they choose to file these cases in our state court system instead of federal court. That strategy, I think, reflects what they expect to find in our court. And I think that this body and the full Senate and the legislature should drill into whether there is a causal connection between the types of persons and the class that is selecting the people that nominate these potential judges, and whether that would be changed if the full state got to weigh in.
Thank you, Mr. Nye. Committee, we have had about 35 minutes of questions for our conferee, our proponent conferee, so we will allow that same amount of time for our opponent conferees questioning. So with the indulgence of those on the committee and those in the committee meeting room and following online, thank you for allowing us to run a little bit over so that we have the same amount of time for all those who want to weigh in on this issue. We will then ask, we have a neutral conferee in person, Linda Browning Weiss. And we will stick to our 3-minute format. Please introduce yourself and welcome to committee.
Thank you, Madam Chairman Warren and committee. It's good to see you again. Thank you so much. Thank you. I have served the state of Kansas for 14 years. I am currently a non-attorney member of the Nominating Commission, having been appointed in 2008 to the Governor's Military Council, where I was appointed by Governor Sebelius, reappointed by Governor Parkinson, and reappointed by Governor Brownback. I've served as state arts chairman, and you have my written testimony, which is about 12 minutes, so I'm not going to read my testimony. You will see that my grandson has brought a box over here, if I could have your attention for a second. All right. I was appointed to the Supreme Court Nominating Commission in 2014. I serve as that's fine, thank you. I serve as the longest serving commissioner on the commission. I've been reappointed, and I have nothing to gain by testifying because my term ends this year. So I will be no longer participating. What I can tell you is that I think there's a lot of misunderstanding about the work of the commission. In 2014, when I was appointed and attended my first meeting, this box, not this box, but one very much like it, arrived in the mail. This is filled, well, I won't take, you have imagination. This is filled with files. I don't think it's commonly understood the vetting process that the Nominating Commission does. It's so exhausting. I have participated in the nomination of 4 Supreme Court justices. I actually led the interview process for Caleb Stegall, and it was interesting for me to hear that mentioned earlier. My lead question to him was, because he was the youngest ever on appointment, I said, well, how do you handle this youth? Because you are very young. And then I asked him, thank you. I asked him about his relationship with the governor. He was brilliant in responding to all that. What I can tell you is that the integrity of the Supreme Court nominee, I have been at every meeting. I have never missed anything. I can tell you the integrity of the commission is beyond question. I understand open records. I understand all that. I was state chairman of the Arts Commission, so I can tell you for a fact there's never been a violation. The public interviews were always very public. There was never anything done under the counter. But what you may not understand is some of the heartbreaking things that go on in the vetting process. For example, with every applicant, we have to do the Judicial Conduct Commission review, Continuing Education Commission, Kansas Attorney Disciplinary Administrator's Office. That can be heartbreaking to find out that someone that you really think is a great potential is not qualified. Criminal background check from the KBI.
Thank you, that's 3 minutes.
Thank you. Credit check by National Credit Reporting. And you would think that a credit check would be a simple thing, but it's not necessarily, and a social media check. I can tell you that every person that we've ever vetted and presented has passed that with flying colors. Some people that I favored so much, I really treasured, did not make the cut. So thank you for your consideration.
Thank you, and please stand nearby because maybe the committee might have some questions for you.
We'll be happy to answer questions. Thank you.
So with that, committee, we will ask, are there any other neutral conferees in the committee meeting room or online? Seeing none, then, does any committee member have a question for Ms. Weiss? Yes, Senator Haley.
Thank you, Madam Chair, and thank you, Ms. Weiss, for being here today. As a neutral, the concern that I have and the question that perhaps you can uniquely answer, do you see room for improvement to the current makeup of the nominating commission, somewhat the hybrid of the makeup of that? Could you briefly opine from your years on it, if there would be a better makeup that might have the vetting process improved?
That's a very
Go ahead, Ms.
kind-
Weiss.
Thank you, Senator and Linda Weiss. That's a very kind question. What I can say is I personally have no idea of political affiliation of any members of the commission, nor have I ever known any political affiliation of any of the applicants. That's beside the point. As you know, the non-attorneys that are appointed are all people who are extremely qualified in their profession. And I want to say I'm the hardest working member of the commission. Now that's a stretch, and my colleagues would not appreciate that. But I work so very hard. I review contracts every day. I have no infractions. I have no lawsuits in 33 years. I may not be an attorney, but I know the law. And I know when I vet people, the people who are honest, the people who have integrity, and I would stand behind any of the 4 people that we have presented for the Supreme Court. I don't know whether it's a good process or not. I don't know. But as far as I was interested in Josh's comments about the questions. I probably was the one who retorted, saying, "Are you concerned about retribution?" Because I would challenge if one of my colleagues said, "I don't want to stand in front of that judge and be judged." I probably would have said, "Are you worried about retribution?" So because I would think that was not a very that would not show character. I can't offer any. No, the clerk of the court is excellent. All the chairmen we've had have been excellent. We've had breakfast, dinners, meetings. We've never violated any open records or open discussion at all. So I apologize. I wish I could offer a recommendation, but it's.
Well, thank you, and thank you,
I
Madam
think the
Chair.
voting
Thank you.
is not understood very well. We vote by written ballot, and then it's made public afterwards. But I just don't think the Supreme Court Nominating Commission, I don't think the work of it's understood at all, frankly. I have worked very hard in our local newspaper. I write letters to the editor. I do all kinds of things to let people know what's going on. But I'm not sure that that's a common thing.
Well, Ms. Weiss, thank you. I want you to know, I personally greatly appreciate your taking the time to come before the committee as someone who's been there, who's been involved with this process. I appreciate your able grandson, whose name I hope you'll say.
Well, I have my lead assistant with me too. They are great help.
That are here
Thank you
today.
so much.
Thank you for making the time
You're
to
welcome.
bring your
Thank you.
testimony today. And thank you, Madam Chair, for your indulgence.
Thank you. Committee, other questions for Ms. Weiss? Seeing none, then thank you for your testimony. We have asked for other neutral conferees in the committee meeting room and online, and seeing none, then we will turn to opponent conferees in person and hear from Diane Belquist on behalf of Kansas Association of Defense Counsel. Please introduce yourself and welcome to committee.
Madam Chair, committee members, thank you for the opportunity to appear here today. I am appearing on behalf of the Kansas Association Defense Counsel. It is a statewide.
Go ahead and introduce yourself.
I'm sorry.
Oh, I'm sorry. Okay, go ahead.
The Kansas Association of Defense Counsel is a statewide organization of lawyers, all admitted to practice law in Kansas, who devote a substantial time to defending businesses within the state. Our organization is an advocate for the administration of justice because our clients depend upon it. The KADC is strongly in favor of our current merit selection. We oppose any change to it. As far as the proposal to have justices elected, the belief is that the judiciary should operate and independent and have only the fidelity to the rule of law and nobody else. Problems surrounding judicial elections can include significant spending by interest groups, which create conflicts of interest for judges who may decide cases that involve their campaign donors. The pressures impede the impartiality of the judiciary, which can lend to less predictable outcomes. And if the perception of fairness is lost, then the public's confidence in our judicial system will be eroded. Judges should decide cases not taking the popular opinion into account. More than ever, it's critical that our judges remain outside of the political fray. Judges are more frequently tasked with deciding divisive social and political issues. So the election of judges has been described as counter to the notion of an impartial court. KADC also opposes Senate confirmation of Supreme Court justices. The Kansas Supreme Court justices have an interest in preserving the status of judicial impartiality, and the bar has that interest in preserving it. The Senate confirmation process could potentially lead to delays in filling positions if there's protracted disagreement on candidates that come before the Senate. Right now, under the merit selection process, the positions are filled in a very timely manner. And so we have that concern as well as the potential for impartiality that would bleed into the court. So the tension between legislature and the courts is intentional and it's old as the United States. Disputes between the branches of government do not constitute a sufficient reason to amend the Constitution or go in search of kicking the judges to the curb because of the tensions. The harsh and difficult fact is that the function of our courts is to apply the law without regard to public opinion. The people have had their say about what the law should be through the representatives in the legislative branch. But when it comes to the application of the laws in the judicial system, every person appearing before the judiciary is equal. And we feel any change to the current system could jeopardize that. So on behalf of the Kansas Association Defense Council, the attorneys that represent business interests in the courts every day, the merit system for selecting Kansas Supreme Court justices is not a problem, and it should remain the continued way forward. I will stand for questions at the appropriate time.
All right, thank you. And committee, we will have questions after we've heard from all the opponent conferees. Next, we will invite Mike Fonkert, Just Campaign Director, Kansas Appleseed, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. I am Mike Fonkert. I'm Campaign Director with Kansas Appleseed Center for Law and Justice. And thank you for the opportunity to speak about these important proposals. I want to start by acknowledging a lot of the proponent testimony, but I feel like what we have here today are two axes on the table, where proponents have really only highlighted a need for maybe a scalpel. We do not support the idea of injecting partisan politics into our Supreme Court. It is incredibly vital that our court make decisions in an impartial manner, and it is clear to see that electing them on a partisan basis or adding more partisan influence to the process will undermine that independence. We've heard a lot of claims today about how lawyers, dominate the selection process. And I think our previous conferee, speaking about the good work of that commission, gives you some insight to that not being the full story. Additionally, we've heard that, this is somehow extreme or so different from how others do it. And I would first say, is an extra precaution of independence truly a bad extreme, or is it a good model here in Kansas? But more importantly, 4 of the 9 members are appointed by the governor. People, through their votes for governor, have a role in choosing the membership of the nominating commission. Additionally, the retention votes that have been spoken about as somehow an anemic mechanism for control, I would disagree. I would say that the reality is that the Kansas population has not been upset enough with any particular judges other than a few over the years to not retain them. And so I think the opposite, that is actually an indication of the court ruling in an impartial way. But more importantly, we are not radical. 28 states fill the Supreme Court nominations through governor appointments with the assistance of nominating commissions. It is, in fact, the most common way for states to appoint their Supreme Court justices. We have a responsibility here to make sure that our court is impartial. And what we must always recognize is that there are few certainties in life: death, taxes, and the fact that nothing stays the same. History marches on, and the wheel of time marches on. Those that are up will be down. If you want to study the history of the U.S. Congress, folks thought the Democrats would never not control the House, but eventually that came to be. Consolidating political power through injecting partisan politics in the Supreme Court nomination process is wrong, and it will undermine the rights of Kansans.
That's 3 minutes.
And I'll just be a nod here, thank you so much for this opportunity, and I appreciate the folks that have done a great job of being timely.
Thank you. I appreciate that as well. Next, we will hear from F. Jim Robinson, Kansas Bar Association. Please introduce yourself and welcome to committee.
Good morning, Madam Chair. Jim Robinson for the Kansas Bar Association. Pleased to appear today. We're a bit daunted by the amount of time considering the scope of the issues, but we'll do our best. In our democracy, we expect our Supreme Court justices to decide questions impartially and to protect our individual rights, even when doing so is unpopular with the people or angers the elected branches of government. But the reality of injecting politics into the selection of judges puts judges in a role that's contrary to that we envisioned for our judges. So take, for example, a judge who is sitting on the court, who is now up for retention or election based on, and is being attacked based on, a legally correct but unpopular decision. Consider, for example, a court that takes a position against one of their supporters, and will that support continue? By injecting politics into the selection process, you have created conflicts of interest that create very real appearance issues as to whether the court can properly form its decision-making process. Our current method of merit selection solves that. We have an independent, nonpartisan commission that vets the candidates, sends a short list of 3 to the governor, and the governor has to choose one. It's a transparent process. It uses specific criteria for the vetting of candidates, which are well known. Our process, as we have created, insulates judges from the political system. So you ask, why do you care so much about this? It is that the Kansas Bar Association believes that we should take the greatest care to insulate our highest court from both partisan politics and the public mood. Now, you're not the first legislature to obviously consider this. Our first Kansans instituted nonpartisan judicial elections. In the early part of the 20th century, they switched to partisan elections. Then they switched back to nonpartisan elections. But even then, the nonpartisan elections weren't curing the problem because parties were still electing candidates. And that led the voters in 1958 to select the nonpartisan Supreme Court Nominating Commission as the model. That was in direct response to public dissatisfaction for putting politics into the selection of judges. We firmly oppose direct elections. As for Senate confirmation, I know of only one other state that uses the model that's being suggested, and that's New Jersey. And the situation in New Jersey clearly points out why that would not work well for us. During Governor Chris Christie's term of office, for 6 years, they were unable to get appointments through the Democratic-controlled New Jersey Senate. That creates a very difficult process. In addition,
We are at 3 minutes.
with this, to date, no state that has adopted a merit plan has rejected it. In 2012, the voters of Arizona, Florida, and Missouri all rejected efforts to move away. Thank you.
Thank you very much. Next, we will hear from Mike Fleming, Kapke Willerth, Attorneys at Law, Kansas Trial Lawyers Association. Please introduce yourself and welcome to committee.
Good afternoon. I am Mike Fleming. I'm an attorney, a lifelong Kansan, a resident of Leawood, and a member of the Kansas Trial Lawyers Association. We represent individual Kansans. I appear today on behalf of KTLA to oppose both SCR 1621 and 1622. There's been some reference to the triple play back in 1957, and I think the net effect of that is that the legislature back then and Kansans agreed that we wanted to remove politics from the process of selecting judges. I think 60 years later, even today, polls reflect that Kansans still want to keep politics out of judicial selection. Partisan elections are inherently political. Candidates for the Supreme Court would be required to raise hundreds of thousands of dollars in order to carry out statewide campaigns. The primary source of those campaign funds would come from lawyers and law firms. Those contributions create perceived conflicts of interest for the justices when the lawyers who contribute to their campaigns later appear before them in court. Our current model, merit selection, avoids all of that. Elections to the court also threaten the independence that is vital for judges to make difficult, if sometimes unpopular, decisions. Alexander Hamilton in Federalist Number 78 said that the fidelity to the law cannot be expected by judges who hold their office through re-election because judges would fear making decisions that displease the electorate and that would be, quote, fatal to their necessary independence. Former U.S. Supreme Court Justice Sandra Day O'Connor also said about electing judges, if the state has a problem with judicial impartiality, it is largely one the state brought upon itself by continuing the practice of popularly electing judges. When Kansans enter the courtroom, they shouldn't have to worry about whether the Supreme Court justices are more accountable to a campaign contributor than the law. With regard to the other model, the federal model.
1 minute.
Thank you. Where the governor appoints subject to confirmation by the Senate, it also has the potential to be excessively political. I'm going to read for you the four most recent justices who have recently vacated their seats on the Supreme Court and give you their confirmation votes as opposed to their successors. Antonin Scalia, 98-0. Merrick Garland was appointed but never received a vote. Neil Gorsuch was confirmed 54-45. Anthony Kennedy, also unanimous, 97-0. Brett Kavanaugh, 50-48. Ruth Bader Ginsburg, 96-3. Amy Coney Barrett, her replacement, 52-48. Stephen Breyer, 87-9. He was confirmed, and Judge Ketanji Brown Jackson is to be determined. These are nominees of both parties, and their confirmation numbers tell the story of rising politicization that now plagues the appointment of justices to our nation's high court. Kansans don't want D.C. dysfunction anywhere near judicial selection. And I would close with this. I believe the current model works. But I would ask this question: why are we attempting to amend the Constitution in the middle of an already busy legislative session and only months from when this issue would be on the ballot? The Constitution.
We are at 3 minutes, so go ahead and wrap up.
Thank you.
You can finish your thought.
I'm sorry. Just this: the Constitution is a document that should only be amended with great caution and should only be done with the most clear and convincing evidence that the proposed amendment is necessary. Thank you.
Thank you. Committee, we have also opponent written only testimony from Mark Tallman, Associate Executive Director, Kansas Association of School Boards, and as well as and want to then ask, do we have any other opponent conferees in the committee meeting room or online? Seeing none, then we will open it up for questions from the committee, and in the interest of keeping the time the same, 35 minutes if we need that long, but go ahead. Any questions for any of our opponent conferees? Yes, Senator Haley.
Thank you, Madam Chair. And this is certainly, I'd like a brevity, if at all, we can employ that from either Mr. Robinson or Mr. Fleming. This is, for me, the big issue is, and both of you referenced it in your comments and in your written testimony, the triple play. And many of us are not familiar with what that is. I won't go into it right now. I thought for a moment, Madam Chair, we would ask our research or reviser to refresh for those or also to explain to others what it is that brought us to this system, what the triple play was in Kansas. Both these gentlemen, Mr. Robinson and Mr. Fleming, did reference it. My question, it has been suggested that the system after the triple play that we now have implemented is sufficient enough that we won't return to the travesty that created this merit selection system that we have. Would either of you gentlemen help us to better understand if we have in any of these resolutions the ability to not return to the highly politicized travesty that occurred during the triple play, which you referenced in your testimony? It has been suggested by the proponents that doing away with the commission and certainly going to direct elections would not revert us to that. What is, please, your insight as to that?
Go ahead, Mr. Robinson. Go ahead and introduce yourself.
Thank you, Senator Haley. Jim Robinson for the Kansas Bar Association. What you need to understand is that leading up to the triple play, we had nonpartisan elections of judges, but then the governor had the authority to appoint a judge to fill a vacancy. And that's how the triple play comes into effect. The merit plan was put in place, and I'd urge you to read the writings of Dr. Rachel Caulfield, a political scientist at Drake University, who studied the historical context and said that the reason why we have merit selection was public dissatisfaction with direct elections. The triple play was simply the icing on the cake. Can we still have a problem? Yeah, we can. Because if you compare the nominating commission with the federal model that we're suggesting, the same checks aren't in place. With the federal model, the governor alone decides who goes to the Senate. It is a king's X. Whereas with the nominating commission, you have the extra insulation. You have an independent commission that's vetted the members. They send a list of 3, and then the governor has to pick 1. So, yeah, we're not completely removed from that realm. And in theory, if you had a sympathetic Senate, you could still have the triple play under the federal model with no constraint.
Thank you, and thank you, Madam Chair, and thank you, Mr. Robinson. Mr. Fleming, is there anything additional you would want to add, or is that sufficient?
No.
All right. Thank you. Thank you, gentlemen. Madam Chair.
Committee. Yes, Senator Thompson.
Thank you, Madam Chair. in listening to the proponent testimony from Professor Ware, I'd be curious as to why this middle ground proposal in 1621 is so objectionable, because the preamble of the Constitution of the United States and in Kansas is "we the people." In other words, everything that we do has a political component. And how could you argue that the Hodes decision was not in some way ideologically driven? And therefore, and I think I heard in neutral testimony that, or one of the testimony, that the population of Kansas was not that upset. Have you not looked at the value of them both movement and the huge sentiment that's come up there? And I think that is the driving force behind this movement to reconsider how the selection process is taken. So if either Mr. Robinson or Mr. Fleming would speak to that, I'd appreciate it.
Go ahead and please introduce yourself again, Mr. Robinson. Thank you.
Thank you, Senator Thompson. Jim Robinson for the Kansas Bar Association. Certainly there are some opponents of merit selection who argue that we have a representative form of government and that the people should have a voice in the selection of judges. I get that. That point is based on a false premise. And the premise is this: judges don't represent constituencies. They don't represent people. They represent the law. You folks do that. They don't have the same accountability that you do. And the reason why is the law needs to be ageless. It needs to continue on without regard to changes of public opinion or changes in political attitudes. And that's why we've created the system that we have. It is to insulate our courts from both political interference and from the public mood.
Would you, though, agree that it's hard, and I think that the decision in Hodes made it very clear that it's very difficult for these judges to necessarily remove their ideological leanings with regard to some of that, and that's part of the reason that we're discussing this now.
Well, you heard the conferee, Ms. Weiss, speak about the work of the commission and the fact that it's not ideological. Well, we know from the confirmation hearings that they are ideological. They're asking particular applicants how they view certain topics. And that leads to the circus-like atmosphere that we have seen at the federal system. The problem that we encounter is we aren't asking our judges, and we never have, to make decisions based on what the public thinks is right or based on what the politicians of the day believe is the proper political agenda. If that was true, Oliver Brown, when he tried to enroll his daughter in the Sumner Elementary School in 1951, never would have made progress because he is a racial minority. He has no political power, and he is swimming against the tide of public opinion. Yet through free and impartial courts, he was able to attain the promise of this country's founding, which is equality under the law. If you add justices that are ideologues, who make promises that when they go to the court, they will go one direction or another, we have lost that ability. And if our judges are simply expected to adhere to what the majority wants, what happens to minority rights? Who's protecting those? And how does a judge square public opinion with the obligation to uphold the Constitution and fairly apply the law? It just can't happen.
Madam Chair, if I may, one more. So the selection process itself, is the Senate incapable of doing that? We just had an appellate court nominee that was of a different political party than the body. And we all met with this lady and felt that her qualifications met what we felt was good, and we approved her. How is that process any different than the Nominating Commission, except for the fact that we are accountable to our constituents, and they send us here to do a good job and to deliberate and vet those type of nominees? I personally think the process works pretty well.
When we amend the Constitution, we have the long game in mind. We're not thinking about what happened yesterday at the confirmation hearing. We have to protect the people against things that we can't now anticipate today. In the present, what is it? The Senate resolution on the federal model, the governor has the sole decision as to who will go to the nominating commission. You have lost the insulation of the independent commission. Maybe you have a lot of confidence in this governor or the past governor, but will you always have confidence in the governors to come? And will you always have confidence that the composition of your body here will have the same impartiality and balance as you're showing? Again, we develop constitutions for the long game, not for what happened yesterday. And it's just really important that we do whatever we need to do to insulate judges from political interference and from the public opinion.
I could probably go on, but I'll yield time back to the committee for any further questions.
I have a follow-up question from Mr. Robinson regarding some of your last comments and insulating our judiciary. Those on the nominating commission are selected by other partisans, if you will, and so how can we be assured that I guess it's a very when 5 of the 9 are of a particular industry, that does have a lot of influence in the nominating process, and I would suppose not insulated from at least one particular industry who has a lot of weight in the process. If you could comment on that briefly, and I don't want to use a lot of the time either, but go ahead.
As in all things, it's relative. There is no perfect selection process. I'm not going to stand here and say that every process keeps politics out. What I am here to say is that the merit selection process is the best of the alternatives, that it better insulates our judges from political interference, from special interest politics, and from the public mood than either the Senate confirmation model or clearly direct election of judges.
Thank you. Committee, other questions? Yes. Senator Francisco.
Thank you, Madam Chair. I have some questions for Diane Belquist. Ms. Belquist, I think you were one of the few in your testimony who talked to the timeliness of the appointments. And I note that with this system, if the Senate is not in session, there will be a delay for appointments. Do you have any additional comments regarding that timeliness of reappointments?
Ms. Belquist, go ahead and identify yourself, please. Thank you.
Diane Belquist on behalf of the Kansas Association of Defense Counsel. Senator, our concern is that there's a 7-member court. And so with any delays with appointments or vacancies that may come about when the legislature is not in session, that leads additional months and timeline before that seat is filled so that we can have that full 7-member court deciding decisions during that time period, as well as if there's a candidate that goes before the Senate and there is protracted disagreement, that would only potentially add to the timeline as far as filling that seat.
Thank you, Madam Chair. I had one other question, and this may be for all the opponents, but I would like to know if they believe it's appropriate to have this constitutional amendment on the on a ballot at the same time as the August primary. One, does that give us enough time to educate the public about this? And are there any conflicts with other constitutional amendments on that ballot?
Go ahead, identify yourself, please. Thank you.
Madam Chair, Diane Belquist on behalf of Kansas Association Defense Council. If I may actually toss that question to Mr. Jim Robinson.
Sure, we'll invite Mr. Robinson if he wants to reply. Or actually, Mr. Fleming, please go ahead and identify yourself. Thank you.
Mike Fleming. And it kind of goes to the last point I was trying to make, which is this feels rushed.
You're with the Kansas Trial Lawyers Association?
Private attorney with the Kansas Trial Lawyers Association. Thank you. This process feels rushed. If 2/3 of both chambers pass this, this will be on the August ballot. That's just mere months away. I know that we have been kicking judicial selection around for some time, but it doesn't have to be resolved this legislative session. If we need more time to study it and bring in stakeholders to talk and analyze all models, we should take it. But this feels very rushed, and so I think it would be problematic to have it on the ballot in August.
Yes, Senator Haley and then Senator Gossage.
Just a brief.
I'm sorry, did Mr. Robinson want to comment real quick? Go ahead and identify yourself, please.
Sure, Jim Robinson for the Kansas Bar Association. Just very briefly, we had 97 years of elections that led to the 1958 amendment. The triple play happened in 1956. There was 2 years to prepare for this process. Yeah, this does feel like we're being blindsided. To do it in the August election in a low information contest that will be difficult for the voters to understand, it will require a significant civics education program on both sides. I mean, this is going to look like a really geeky election, but there's going to be civics education that will play out, which would be a good thing for the edification of the voters of the state of Kansas. But I think that it's very difficult in the current time frame.
Thank you. Yes, then we had Senator Haley and then Senator Gossage. Thank you.
Thank you, Madam Chair. I just reread some of the written testimony, and it referenced my concern with, the triple play, and did see that both Diane Belquist and Mike Funkert, too, in their written testimony had referenced it, and I didn't know if there had been any intervening concern that they may express just in terms of the equity in that. The last two conferees that had spoken, Mr. Robinson and Fleming, I had leaned on. So very briefly, if there is something pertaining to the triple pay, and if Mr. Funkert and or Ms. Belquist, by all means.
Mike Funkert, Kansas Appleseed. I would say just in response to the triple play notion being fixed, right now the Senate is a great check on the governor because we have a Senate that has a majority of one party and a governor that sits in another party. But if that were not the case and the governor and the Senate majority lined up, I'm not convinced that they would always be a satisfactory check, as has been shared today. Thank you.
Thank you. And or Ms. Belquist, if you're satisfied, then you're good. All right. Thank you, ma'am. Thank you both for your testimony. And Madam Chair.
Senator Gossage.
Thank you, Madam Chair. And very quickly, and I believe this is for Mr. Robinson as well. You have mentioned a couple of times that Kansas does not want the circus of the federal model, but yet we have that already, do we not, with the Court of Appeals? Would you consider that a circus?
Please identify yourself.
Yes. Thank you, Jim Robinson, Kansas Bar Association. Yes, we have that, and we opposed it back then in 2013 when it came in. Our preference is merit selection across the board. The legislature rejected that. That's a statutory court. The Kansas Supreme Court is a constitutional court. It requires supermajorities in the House and the Senate and a majority vote of the people to bring that into place.
So I'll ask one more time. So in the last 9 years since this became law, have you seen this to be a circus?
Have I seen it being a circus? Again, we are preparing for the long game. You may have done well in the past and may feel comfortable with the way things progressed. But we prepare constitutions thinking about all possibilities. When the governor is not of someone who is of your liking, and if the Senate is of the opposing party, we will have the circus that played out in New Jersey for 6 years during Governor Chris Christie's administration, where he could not get a single appointment through. That is a I believe it's a seven-member court for the New Jersey Supreme Court, and for many years they operated with 4 members. When you have 4 members of a court, you have increased caseloads and backlogs, which leads to great delays in deciding cases. And for someone who appears in courts every day, my clients want an answer. They don't have the luxury of waiting years to get an answer because political antics are preventing an appointee from sitting on the court.
But yet we do have in statute, do we not, that if somebody is not appointed or if the Senate does not make a confirmation, then we have a recourse, do we not? You wouldn't have to wait for years. We would not have to wait for years to be able to replace a judge. Do we not have in statute that should the Senate and the Court of Appeals not confirm a judge, that the governor can then appoint another person? Are you suggesting that this could last years?
My comments are not related to the Court of Appeals. My comments are going to the proposal for the Supreme Court.
Again, I will just ask, could the Kansas Board of Associations not create their own commission and give recommendations to the governor without it being a requirement in statute that the governor must choose from the 3 nominees?
Well, again, you're putting a lot of confidence in the governor. And historically, based on what's occurred, there's good reason to have suspicion. The commission that we have that's mandated by statute provides that extra layer of insulation that you completely lose when you get rid of the commission. Now, when we talk about the federal model, there are at least 10 states that use something like the federal model, but they have the nominating commission on the front end. The nominating commission has great value. If you're comfortable always trusting the governor, so be it. But I think our history has shown that that is fraught with problems.
Thank you, Mr. Robinson. I have one question for the proponents. I can hold until we're finished with the.
We're on the opponent conferees.
Correct.
Now,
so I'll wait.
Thank you. Yes, other questions for our opponent conferees? Senator Francisco.
Thank you, Madam Chair. I have 2. Probably the first, again, for Diane Belquist. And we're talking some about what we have seen in appointments to the Kansas Court of Appeals that's handled differently. I believe you had some comments about filling the vacancy when Carl Folsom was appointed. Can you give us just a brief comment about that?
Good. Ms. Belquist, introduce yourself.
Thank you. Diane Belquist, on behalf of the Kansas Association of Defense Counsel. Our position would be that's an example of where politics had entered into the factor of choosing who was qualified to be appointed and seated on the Kansas Court of Appeals. And so our position is that did not go as well as we would have hoped it could have gone, because his experience was characterized as such that ultimately he didn't pass with Senate confirmation. Thank you.
Thank you.
Go ahead.
And Madam Chair, my other question is for Linda Weiss. If I can go, I'll wait. I guess I have to wait on
let's
that.
just keep it to the opponent conferees.
Okay.
Thank you. And I have two questions for the opponent conferees that are in the same area that I asked before. But before I get to those, we heard about political antics on behalf of others than the judiciary, and then we heard that there were political considerations when, through Senate confirmation, the Senate does not confirm a Court of Appeals appointee. So we also heard a question about the Hodes decision, and we want timely decisions and not political antics. And I think that I would have to ask research, but I think that case was submitted for decision a number of years before the decision was rendered in 2019. So I suppose we're talking broadly in a number of areas in what we're discussing today, but I have two specific questions for our opponent conferees, and they are this. The first regarding the written testimony from the Attorney General Derek Schmidt, where he has stated now, as in 2005, I am advocating this amendment out of a sincere belief that this reform will result in a stronger and better respected judiciary. So my question to the conferees, like I asked the proponent conferees, is do you agree with that statement, that an amendment like this will result in a stronger and better respected judiciary? Thank you. Mr. Fleming, please introduce yourself.
Mr. Fonkert, Mike Fonkert, Kansas.
I'm sorry, it's a good thing you're introducing yourself
then. No, Kansas Appleseed would not agree that that would create a stronger and more respected judiciary. Again, I think if the Hodes decision is one that the Kansas voters are upset with, they will hold those judges accountable when they are up for retention. So, no, we do not believe that these changes would strengthen the judiciary and would, in fact, do the opposite.
Thank you. Any of our other opponent conferees? Mr. Robinson.
Thank you, Jim Robinson with the Kansas Bar Association. The litmus test for any method of selection should be one that insulates judges from politics and from popular opinion. I would respectfully disagree with the Attorney General. Merit selection by far provides insulation against those two things that neither direct elections nor the Senate confirmation process after a governor appointment would have. So, yes, I disagree with the Attorney General.
Any other opponent conferee that I put the question to? And I would then ask, as I did the proponent conferees, that putting this on the ballot, if any proposed constitutional amendment were to pass both chambers of the legislature, allows the people of Kansas to have a say in which particular method of selection of the Kansas Supreme Court justices Kansas is going to employ. If a proposed constitutional amendment is on the ballot and it is passed by Kansans, that will be the system. If it is put on the ballot and rejected, we retain the current system. And the reason that we heard from the Kansas Attorney General that advocating for the amendment of federal model Senate confirmation is, first, it is time for the people to vote, to let Kansans decide which system do they prefer. We heard today there's no perfect system. So I would ask the opponent conferees, the two reasons given by the Attorney General advocating for the amendment is, first, it is time to let the people of Kansas vote. And second, the federal system of judicial selection works and has for more than 2 centuries. I think my question for the opponent conferees is more the first point raised, because I think you have all already addressed the second point. But the first point, is it time for the people of Kansas to vote on how they would like their Kansas Supreme Court justices selected? So I would pose that question to the 4 opponent conferees. And please identify yourself. Thank you.
Mike Fleming, Kansas Trial Lawyers Association. I think it's problematic, given the time frame that we've referred to already, that we are now in March and the issue would be on the ballot in August.
But this has been an issue that, as we have heard, in fact, there was an amendment proposed in 2005, and there was an interim committee in 2019 of the legislature to particularly study this issue. So I'm just curious. I've heard the opponent conferee state that it's a new issue, and I think it's been around for more than 17 years. So
right. And if there was an interim committee and a study was conducted, what are the findings of that study? And where is the clear and convincing evidence that these amendments are absolutely necessary? I guess I would raise that.
Is it your position that in order to put a constitutional amendment on the ballot, there has to be clear and convincing evidence?
Yes, that an amendment is necessary. I don't think we should take amendments lightly.
And do we have that in law anywhere that it's clear and convincing evidence, or that's just the opinion of
That's just
Kansas
the opinion of Mike Fleming.
on behalf of the Kansas Trial Lawyers Association?
Yes.
Correct. Okay, thank you. For the other opponent conferees, the question was, we heard from the Kansas Attorney General that it's time for the people of Kansas to vote on the issue. Mr. Fonkert, I think I have that right now. Thank you.
Thank you, Madam Chair. I would say that, again, this time frame for this current round of proposals is too short for Kansans to fully consider the implications of what we have going on here. I would also say Kansans have already spoken. We chose this model many, many years ago, and it is not lost on me that only since 2005, in the new age of ultimate, hyper-partisanship, are we now considering a change? For the 40 plus years prior to that, it worked fine. But now as politics have continued to grow more divisive, now we see folks wanting to change the system. And I think that actually reiterates our need to be cautious and not move too quickly with these kinds of proposals. Thank you.
Thank you. Any other opponent conferees on that question? So, all right, we have a few minutes left if there are other questions for our opponent conferees. Seeing none, then want to thank our opponent conferees as well. We had a question from some of the senators to ask questions of prior conferees. That is not the usual practice in committee, so we're going to keep with our usual practice and not go back, if you will, but want to thank everyone for appearing today and your consideration of the issue and the thoughtful testimony presented on both sides and neutral as well. And it's something for the committee to take into consideration. And thank you for those who appeared on WebEx as well, those who are following along online, and those who will possibly take a look at this after we conclude today. So thank you all for the discussion and consideration and the hearing on SCR 1621 and 1622. We will now close those hearings and want to thank everyone. We are adjourned.